Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and this is the second in a series of sessions looking at discrimination law in the UK. In the first session, we looked at what is a disability for the purposes of the Equality Act. In this session, I want to give you a very brief overview of the rights that are created where somebody is disabled. And in the third session, I'm going to focus on reasonable adjustments, the steps that an employer should be taking to accommodate disabled employees. So, what are the rights that are created? Well, there are 5 different areas I want to focus on. The first is perhaps the less used area in practice. This is the idea of harassment. And there is a statutory definition within the legislation of relating to creating an intimidating and hostile working environment for the employee. So this will be where complaints about the language that's used in the workplace, jokes, banter, that sort of thing will come out, where somebody says, actually, I find the way in which I've been treated offensive because of my disability, and challenge the employer from that perspective. The second area that you'll probably be familiar with is the idea of direct discrimination. Now, this is where somebody is saying, because of my disability, I've been less favourably treated. So it might be saying, but for my disability, I would have been promoted, or but for my disability, I would have been recruited in the first place, or but for my disability, I would have been able to go on that training course. It's those kind of arguments. And the employer is not able to justify that. If they're found guilty of direct discrimination, then they are in trouble. The third area is special to disability discrimination, and this is all to do with unfair treatment because of something that's connected or as a consequence of a disability, where the employer can't justify that treatment. So it's probably best illustrated with an example. I may say I have asthma, and as a result of my asthma, I get all the coughs and colds that are going, and it can make me unwell, and I end up having to take time off work. Now, the employer may have an absence management policy that means, as a result of the amount of time that I've had off work, I receive some kind of disciplinary process, perhaps a warning or something. Now, under this provision of the legislation, the worker may say, well, hang on a minute, the reason why I've received my disciplinary warning is the amount of time I've had off work, but the amount of time I've had off work is as a consequence of my medical condition. And actually, that's unfair. I shouldn't be being penalised in this way for having that medical condition. Now, the burden then shifts to focus on whether or not it's reasonable for the employer to have taken that disciplinary action. Obviously, the employer will argue that managing absence levels and encouraging everybody to attend work as much as possible is a legitimate aim to pursue. So the question then becomes whether or not there was less discriminatory means of achieving that aim through that policy, and that's a question for the tribunal in any particular case. The other area to bear in mind is indirect discrimination. Now, this is the idea of the employer having some kind of policy or provision or criterion or practice that applies to everybody, but it may have a discriminatory impact or more disadvantageous impact on the disabled worker. So an example would be the employer requires the employee to drive to appointments with customers. For somebody with a disability, obviously driving may be more of a challenge. Indeed, they might not be able to drive at all. So the employer has got to justify having the requirement to drive, as opposed to perhaps managing it through other means. I don't know, maybe getting public transport or a taxi or something like that to the appointment. Again, the employer has the opportunity to justify that their requirement is a proportionate means of achieving a legitimate aim in that case as well. The final area to think about in terms of rights is reasonable adjustments, and I am going to do a whole session on this area because under the legislation, the employer is required to not only make physical changes to premises to ensure that disabled people aren't put at a disadvantage, but also make adjustments to work arrangements and policies and practices to remove any substantial disadvantage that puts the disabled person at. So that's what I'll focus on in my next session. Thank you for listening.